The Supreme Court today clarified a very important part of the governor's assent to bills that are passed by state legislature. What is the full scope and time limit that can be given to such an assent? Whether a time limit can even be set or not. These are the clarifications that have come from the Supreme Court. In this video, I will explain to you why this is crucial and where has this come from. Let's remember that there was a case between the Tamil Nadu Governor and the Tamil Nadu State Assembly in the Supreme Court. There it was decided that the governor cannot indefinitely hold a bill or cannot exercise a veto power over a bill. So let me give you the full story. The Supreme Court has delivered a landmark clarification on the powers of the governors and the president when it comes to bills passed by state legislatures. The court has ruled that no fixed timelines can be imposed on these constitutional authorities for granting assent, withholding assent, or sending a bill back for reconsideration. It also made it clear that the Constitution does not recognize any concept of deemed assent, meaning a bill cannot be automatically considered to have become the law just because a certain number of days have passed without a response. The court explained that Articles 200 and 201 give the governor and the president discretionary space to examine a bill carefully and take a considered decision. However, this discretion cannot be used to stall legislation indefinitely. If a governor holds a bill for an unreasonably long time without justification, the court said that such a delay may invite limited judicial review. The judgment emphasizes that lawmaking process is a balance between legislature's democratic mandate and the constitutional duties of the executive. While deadlines cannot be forced onto the constitutional officers, unreasonable inaction or delay can be questioned in rare and exceptional situations. This ruling now becomes a major reference point for future disputes between state governments and Raj Bhavans across the country. The judgment stems from a reference by the President via Article 143 made in the aftermath of the earlier two-judge bench decision in the Tamil Nadu Governor case. The five-judge bench comprised of Chief Justice B.R. Gavai and Justices Suryakant, Vikram Nath, P.S. Narasimha and A.S. Chandurkar, who answered 14 questions laid out in the reference. So this actually now sets the record straight that there is no such thing as a deemed assent. If the governor is taking his or her time to return a bill after its assent or for reconsideration, there cannot be an assumption that beyond a certain period of time, the bill is considered accepted. There is no deemed assent concept as per the Supreme Court. However, in the earlier ruling, it was made clear that the governor cannot sit on a bill for an indefinite period of time. It has to be either accepted or returned for reconsideration. And should it come back the second time around, then the assent is assumed. So that part is clear. But insofar as the Supreme Court setting a deadline to give assent, failing which the bill will be considered passed or given assent to by the governor, that part the court has said there can be no such provision, there can be no such time limit set, and there can be no such thing as a deemed assent. Thanks for watching. I look forward to your comments. Do subscribe to Free Press Journal for topics such as these where we give you clarity of the concept.